So hi everyone, thank you for joining in on our day 2 for the delegation to India, specifically targeted to supply chain tech, logistic techs and e-commerce. Today we have Karun Cariappa, who's the founder of FernBank Holdings. Karun is the founder of FernBank Holdings, which supports corporates, founders, startups, funds and family offices when executing complex and challenging transactions. He was previously the partner and the head of the India practice at Morgan Lewis Buckwitz, a large US-centered international law firm, before he set up FernBank Holdings. He is featured in the India Business Law Journal's top 100 A list of international councils advising on India related to matters as a lawyer of repute. He is an alum of LSE, London School of Economics, and is a charter member with TiE Singapore. Along with Karun, we have Vishnu, Jerome, who's the partner with JMP Law. Together, they would be talking about Indian legal and tax one-on-one, which would be imperative for you to, and that knowledge would be imperative for you when you're thinking of India as an expansion market. Vishnu, Karun, over to you.
Thanks very much, Siddhi. It's a pleasure to be part of this journey for all you young startups. Vishnu and I have known each other for a long time. We started off working together in Mumbai many years ago, and we've kept in close touch over the years. And these days we collaborate on a number of transactions together. So it's both his and my pleasure to make this presentation to you guys on your day 2 of this India Immersion Program. So the way that I thought that we should structure this is that we'd give a brief overview of the legal landscape in India. I know that legal may not be top of your priority as y'all are undertaking your businesses and y'all are looking to expand into marketing and getting investors, etc. But nevertheless, it's what I find is that legal and a lack of attention to some of the legal matters becomes an issue as you grow your business. So I hope you find this informative. Please, feel free to interject, stop me whilst I'm speaking, or stop Vishnu whilst he's speaking, and ask questions. We will be as informative as we can. But yes, this is meant to be an interactive session. So this is not guided by any set format. So please, be flexible. So just moving to the next slide. So we're going to talk about 4 main topics today, which I will be taking, which will be the introduction to India's legal system, the nature of your presence in India. How do you actually want to be in India? Do you want to be as a limited liability partnership? Do you want to be as a partnership? Or do you want to be as a private limited company? Human resources, some of the things that a lot of people find challenging, international companies find challenging in India, is the human resources. And of course, intellectual property, since this is, young startups who are doing things in India. There's intellectual property rights, patent control, trademarks, copyrights, all of these things also which need to be covered. So I'll cover a little bit of detail on intellectual property. So going to the introduction of India's legal system, most of you guys, if y'all are from Singapore, y'all will be quite familiar with this concept. It's a common law system. When I say common law, what it really means is that we have a system where the rule of law is actually determined by the courts, and as a result of which they determine a judgment, they pass a judgment, and that judgment becomes a precedent. Then it becomes the law of the land, because all the junior courts to it will then have to adhere to the rulings and to the judgment of the senior courts. We also do have a constitution, unlike the UK system, which is basically the origin of common law basically comes from the UK system. We do have a written constitution, and the written constitution basically enshrines various rights to the people of India. The constitution also does demarcate a division between the state and the center. So the center is a federal system of government, and then you have the central government which runs the center, and there are certain policies that the central government passes legislatures on, And there are certain other matters which are delegated to various states. So each of the states in India have their own mandate, which is enshrined in the constitution, to cover certain aspects and certain laws in order to sort of divide the manner in which legislation and rules of law are passed. We also have delegated legislation, so which basically means that there are certain administrative bodies which are entitled to undertake certain quasi-judicial functions. In terms of hierarchy of courts, we have the Supreme Court of India, which is the highest court of the land. It's generally the appellate court, and steps in only when there are certain matters which are super important matters which come up before it. Below that, you have the high courts, which also determine on matters relating to civil, judicial, civil and criminal law. Below that, you have the district magistrates, and below that, you have the civil and district court judges. And these civil, these are divided into criminal courts and civil courts, and you have Division 1 and Division 2 of those court systems. Going to the nature of foreign entities establishing their presence in India. So the way in which there are a number of entities through which you could basically set yourself up in India. One is what you call a liaison office. The other is a branch office. You could be a limited liability partnership, or you could be a private limited company or a public limited company. So there are certain differences that you need to understand before you set up your operations in India. As an unincorporated entity, you can have a liaison office where you basically are a representative office. So it means that you have to seek the permission of the Reserve Bank of India in order to set up your liaison office. You can't really undertake commercial activities. And the only sort of option that you have is to basically act as, a liaison between your parent office, which is established outside the country, and also your various customers. So your outside incorporated entity would then be able to book that revenue. You have to maintain yourself separately from, the remittances that you receive from your parents. And like I said earlier, you need the approval of what you call an authorized dealer, who is basically a bank which is authorized by the Reserve Bank of India in order to establish your liaison office. And this approval is valid for about 3 years, and then it may be renewed when you go back to your authorized dealer for approval. The next is a branch office, which is sort of similar to the liaison office, except that it requires a prior approval, again, of the authorized dealer to set up. You can actually then represent the foreign parent company in India and act as buying or selling agents in India. Branch offices may also remit surplus revenues to its foreign parent company, subject to applicable taxes. So basically, as a branch office, you're allowed to interact with your clients, obtain revenue from your clients, and then remit some of that revenue back to your parent entity. So generally, though, this is not a means through which startups or companies that are looking into to work in the e-commerce space use to establish their presence in India. It's generally used by research and development operations in India. Moving on to project offices, these are project offices where a foreign entity has a specific project in India. They have a contract which they basically say allows them to establish their presence in India. They'll have to show that contract. You're permitted then to operate a bank account, and you may remit surplus revenue from the projects to the foreign parent as well. So this is again for one-time turnkey operators who are sort of exploratory mode, shall I say. They come into India and they have a contract which allows them to do certain things, but then it's not a full-fledged established presence, so to speak, in India. Partnerships, you've got this concept in pretty much all around the world. It's, you have a partnership deed, which determines the rights and liabilities of the various partners. You have equal rights to participate in the management and control of the business and the profits, losses, depending on how much you contribute to the partnership. The next is trusts. Trust is, it's I think beyond the scope of this conversation, but these are generally entities that are created for certain assets to be handled by trusts and trustees. Now, coming to incorporated entities, you have the concept of a limited liability partnerships. This, is typically used by, a lot of law firms generally use limited liability partnerships. It has the ability to protect the individual partners from the liabilities created by the other partners' misconduct. So if you take, for example, it's basically its own judicial entity. So, there's the concept of lifting the corporate veil and, having a separate entity separate from the people who have founded those entities. So this is a mechanism through which you can, without the complications of incorporating a company in India, you can have a limited liability partnership, which allows you to function in India. The next one is, private companies. I'm sure most of you are familiar with private companies, since most of y'all may have been incorporated. So here, a private company in India is, you have the ability to restrict the transfer of your shares. The number of members of the private company must be a minimum of 2, and there's a maximum limit of 200. You can't really allow the public to basically come in and buy shares in your private company. Of course, once you guys have your investors who come in, you will have, you'll be still restricted by these restrictions under the private company's sort of limitations. But then when you're looking to go IPO, then you convert your status from a private limited company to a public limited company. And a public limited company in India, must have a minimum of 7 members and have more than 200 shareholders. You may invite the public to subscribe once you go public, and you can list your shares on the recognized stock exchanges by way of an initial public offering. And there is one guidance which Indian Companies Act basically states, which says that you must maintain a minimum public shareholding of at least 25%. There is some talk right now where large companies are allowed to undertake an offering of shares where they're offering less than 25%, but that's, I think, still being discussed with the regulators and various interested parties in India. Does anyone have any questions at all? No? I'm sorry, I couldn't hear that.
Maybe if I suggest, if you guys have questions, you can just put it on the chat as well, and we can pick that up.
Yeah. The next point that I was going to discuss was human resources laws in India. Now, India is quite a complicated place when it comes to human resources laws. The employment laws don't flow from one particular act. There are over 50 national and over 150 state laws governing subjects ranging from conditions of employment, social security, health, safety, welfare, trade unions, industrial and labor disputes, etc. Now, this is quite important from a perspective of, if you have a warehouse, if you have labor who are working in the warehouse, if you have e-commerce companies, you have delivery, riders who basically go and deliver your products to various people, to your customers. So it's quite important for you to get specific legal advice when you are setting up your entity in India. Like I mentioned before, there are over 50 national and over 150 state laws that govern these subjects. So each particular state has its own peculiarities with how you set up your establishment, how you have contracts with various people in the labor force, and how the labor force is actually protected by the state legislations. The exact applicability of each labor law is determined on the basis of the nature of the work that's undertaken. Now, generally, you have blue collar workers who are protected under labor law. White collar workers, professionals, aren't generally protected under labor laws, so to speak, in India. But it goes into details such as what is the nature of your establishment, how many employees do you have, what are the roles and responsibilities of the employees, what is the salary and compensation, and what is the duration of employment of these employees. Before you set up in India, I think it's very important to get very specific local advice as to all this setup, and also as to what the impact could be, potential impact could be for you to hire local people on the ground. General terms of an employment contract, these are things that you need to have when you employ people in India, or people anywhere in the world specifically. It basically highlights what the role of the employee is, what the compensation structures, duties and responsibilities. If there are any conflicts, there should not be any conflicts of interest. You should not be doing something which is detrimental to your company. You'll have a confidentiality and non-disclosure clause out there, which basically says and states that these employees should not be divulging any of the information that they've obtained. In today's world, where there's a lot of data privacy laws in place, I think this is quite an important thing, quite an important clause to have in place. So you need to make sure that it's watertight. You'll have intellectual property and assignment. Now, where you're a software company or you've got codes that you'll make, then you need to specifically determine who owns that code that you've created, or who owns that IP. Obviously, if they're in your employ, it'd be preferred if you specifically state in your contract that all of the intellectual property that they've created whilst being in your employ are the property of the company itself. Non-compete and non-solicitation obligations. Obviously, if these employees decide to move on to a competitor, you'll need to put in some sort of non-compete clause out there where they can't compete for like a certain period of time, and non-solicitation where they can't actually go and take your entire team and walk away into a new organization. Now, I think this particular non-competes and non-solicitations have been subject to judicial review. Generally, the non-competes work when you are in the employ of an organization. But if you've moved away from the organization, the courts have basically taken a view that it's a restriction on being able to undertake your own trade. So it becomes a very difficult one for you to enforce after the employee has left your organization. Nevertheless, it's still quite an important clause to have in your agreement to make sure that you just basically explain to them that they're not allowed to actually compete with your business, because obviously you want to protect all of the intellectual property, all of the client contacts, all of the know-how that you've developed while these employees have been part of your organization. Dispute resolution is, if there's a dispute, if an employee wishes to walk away, and there's a dispute with respect to payment, etc., you need to make sure that you have a dispute resolution clause which talks about which forum you can actually approach if there is a dispute, so that it's contractually agreed to. You could do arbitration, you could do mediation, or you could specifically state that that the dispute needs to be brought before a particular court. Like I was talking about earlier, non-disclosure agreements. You need to, these NDAs that you generally have when you either go to a potential client or you have a potential investor who's looking to invest in your company. You have NDAs which define what confidential information is. Now, this is quite critical because you need to be able to point to that clause and say that, look, all the information that I've shared with you does constitute confidential information. There are certain exclusions. Certain exclusions can be information that's already out in the public domain. There could be information that has come to you through a third party and you did not know that this was information that was confidential. Again, this will all need to be set out in your NDA agreement. There generally is also a term within which you need to keep this confidential information confidential. The term it varies. Sometimes you have, you're dealing with extremely sensitive intellectual property, and sometimes people say that they want to have 3 to 4 years of this information that this information should be kept confidential, or you can vary it. So generally this is something which is heavily negotiated as well. Then you also have the ways and means through which you can use confidential information. There's permitted usage. You need to use it only for restricted purposes, and you can distribute it to other people only on a need-to-know basis. And you also need to basically let these other people know that this is all subject to confidentiality. So these are all terms that you typically have in NDAs, and it's quite important that you actually get someone with a legal background to take a look at these NDAs and make sure that you're well protected. As I mentioned before, non-competes and non-solicitation agreements during the term are generally enforceable, but post-termination, these are generally not enforceable. I've already touched upon this. Intellectual property, I think Vishnu will go into more detail on this particular point, but just from a framework perspective, I just wanted to highlight that intellectual property, India is a signatory to the International Conventions on Protection of Intellectual Property, and Indian courts also do take a stand where they protect your IPR, and they protect your IPR despite not being registered in India in certain circumstances. So copyright, computer databases and software programs have been protected under copyright laws in India. Trade secrets and know-how, however, are not protected by any specific statutory law in India. But they are generally protected under your contractual obligations. This is over to you, Vishnu. Let me see if if there are any specific questions that we need to address. First one is from Dhana Ulavi. Is there any cool-off period the law accepts for non-compete? Like I mentioned, during the course of your employment, the non-compete is effective, but after it's difficult to enforce. So you could probably put in your contract saying that you can't compete for about a year or so. But if that employee does go and push, then is generally not enforceable. I think, sorry, Vishnu has already addressed that question.
Can I add one more thing?
But you can answer it because I've just shared it back to everyone.
Yeah. Just that is for the employee. But how about the co-founders or what do you call the founding members who also have shareholding in the company and they want to leave or pursue something else? Is it enforceable that they don't start something of their own, or they don't go and join the competitor? Is there any cool-off period that we can apply?
So this again would be contractual. I don't think the law actually has anything specific in there. So contractually, you can put in something which says that you are prohibited from, as a founder, you're a co-owner, you're prohibited from actually moving to a competitor, or you're using any of the know-how that you have developed. But now the problem here is again enforceability. It's something that needs to be taken before a court of law, and the court of law, if it determines that that this restriction on your co-founder to go and start up his another enterprise, another business, is unduly restrictive, then there could be a potential where the law could basically say that your contract is no longer the non-compete is no longer enforceable. So this is all subject to judicial review, unfortunately. So I don't believe there's any set law in India which says that there's a specific cooling off period which will be enforced by the courts.
But just Karun, so I can add to that. So there's no set law, as Karun has rightly said. But in terms of business arrangements, shareholding arrangements, where businesses get transferred, or you buy out the share of the founder, for which value, there's a certain amount of goodwill also factored in. In those situations, non-competes would be enforceable because it's not linked to employment. So where it's linked to shareholding transfers, where it's linked to business transfers, especially where the seller has shares in the goodwill of that particular asset which is being transferred, you would see for reasonable time periods, and for it not to trigger the unreasonable restraint that Karun talked about, but for reasonable time periods, taking into consideration the nature of the business, you would see anywhere between 12 to 36 months being put in. Not all of them have been tested, but there is judicial precedent where business transfers and share transfers are concerned, where some form of a reasonable non-compete based on the nature of business would typically be enforced by the court. And as we've pointed out in the chat as well, non-solicit obligations as regards clients, customers, employees, IP and confidentiality, that will be enforceable post the term of the contract, irrespective whether it's employment or linked to the business or shareholder.
Yeah.
Hey, okay, thank you. Yep, thanks.
Okay.
Yeah, so I thought, so thanks, Karun. That was, I hope, useful in terms of primer to how do you set up various business organizations in India. The next section will briefly deal with, your actual investment transactions or your actual commercial arrangements of doing business in India. Whether you do it through a Singapore entity, which is setting up a wholly owned LLP or a wholly owned subsidiary in India, or whether in the initial phases, you choose to have more of a contractual arrangement with an Indian counterpart. So generally, as far as the investment and M&A scenario in India has been over the last 9 months, even though we've been impacted by the pandemic. I think technology sectors, banking, pharma, healthcare are avenues where we've seen a significant amount of deal activity, including among startups, where a host of startups have been given various stages of seed or up to Series A funding in India. Including through these past 9 months, and as per official figures, it's been a 40 billion FDI inflow into India. 2021, Singapore, because of our favorable treaty between India and Singapore, as far as the double taxation is concerned, continues as it has been over the last 2-3 years to be the biggest FDI investor in India. So as far as technology related businesses are concerned, across the spectrum, there is still a lot of positive deal flow and new businesses which are being set up. So for you guys, I think that still remains a positive, though there are lags in other parts of the economy, just like most of the world, I suppose, given what we're going through. So I think in terms of foreign investment and doing business in India, as Karun said, 2 or 3 primary ways that you can come in. One is setting up a wholly owned subsidiary or an LLP in India, which undertakes the Indian leg of the business. As far as FDI is concerned, in most technology platforms, and we've seen some of the information that you folks have shared. Most of that would be under the 100% automatic route as far as foreign investment is concerned. So there is no prior government approval which is required. You can invest up to 100% in a technology platform-based business. The same applies for e-commerce with a couple of caveats. E-commerce on a B2B business is allowed 100%. E-commerce in a market-based model, which is not an inventory-based model, is also permitted. Essentially, an inventory-based model, as the term would suggest, is that the entity which is set up, say by one of you all, should not own or control the goods or services which are being traded between the vendor and the buyer on that platform. So the actual trade of whether it's a product or whether it's a service will be between a vendor and an end customer who's just using your platform as an interface to undertake a particular business. So in those marketplace e-commerce businesses, FDI is permitted. Inventory is defined slightly restrictively. So of course, if you own it, then clearly it falls within. They also use the word control. So where you have shareholding interest of say more than 25-26% in a particular entity, and that entity is the actual vendor of the goods or services, then that is considered as control, and you can't use such vehicles to bypass this inventory-based model restriction. As far as funding is concerned, I think for businesses such as yours, I think there'll be 2 or 3 routes of funding. One is obviously actual equity. 2, for taxation and cash flow reasons, there could be some amount of funding and repatriation which happens through royalty or service agreements, where the Singapore entity maybe provides certain services to the Indian entity and advances it money, on a short-term basis as an advance against services that it may procure from the Indian entity, and thereby keep the funding going. But we'll just go through each of those methods first. The first is pure play equity. Indian regulations have a rule saying that any investment must be at least at the fair value of that particular company. So from both a taxation and a foreign investment perspective, each time you fund the equity, there will be a fair valuation, typically done on a discounted cash flow method. So based on projections, and that would be the value of the equity that you fund. If you're a wholly owned subsidiary or an LLP, typically a wholly owned subsidiary, if you're doing a rights issue, the pricing guidelines are slightly more relaxed. But again, if you don't come in at a fair value, you could face taxation issues. So typically, all your equity funding will be based on a fair valuation methodology. There are hybrid debt or pure debts that you can also offer, though there are restrictions in how that debt can be used. So typically for capital expenditure, limited working capital, they also have lock-ins of about 3 years depending on the type of instrument. So for technology related platforms, debt becomes a little more difficult as a funding option, and therefore we come to the last bit where funding can happen as an advance against certain services, back office services that the Indian company is providing. So you give an advance and you monetize your investment by way of royalty agreements for the use of technology or the use of your brand name. From a taxation perspective, quickly going on equity, repatriation is fully allowed of dividend if there are distributable profits, but there's a tax of 10 to 20% on that dividend which is distributed. It's a tax deducted at source. This is on top of the corporate income tax that you would have already paid, so it may not be the most efficient method. Whereas in your royalty agreements or other technology transfer agreements that you can enter into with the Indian company for transferring technology know-how and your trademarks, if you earn a fee on that, that typically under the India-Singapore Treaty is taxed at about 10% and also can be treated as an expense and therefore deducted from the Indian company's overall corporate tax. So you kind of probably will do a combination of equity plus technology know-how arrangements, both from a funding and a monetization perspective. If there are any questions here on the investment part, happy to take them.
Hi, Dana here again. So if the investors say we have a HQ in Singapore, but we also have created subsidiaries in India, and the investment route, it has to be from Singapore into India, or it can go directly into India subsidiary also, because there are some investors who are happy to do it via the Singapore HQ route, being a parent company. The subsidiaries are for the local investors who wants to, it's also the company's interest, not the investors' interest, but say, for example, we want to dilute the shares purely in the subsidiaries. Is that possible to do that, or it has to be always via the HQ into subsidiaries?
No, it can be directly, so investors can go directly into the Indian company. And not necessarily go through the Singapore company. So particularly when you're raising, if you do raise capital and you're looking at Indian investors to also contribute to the capital, there are some structures where people invest directly to the Indian subsidiary. The only challenge that you may face, right, because people prefer to come through the holding company in Singapore for a couple of reasons. The ease of it's much easier to do an exit at Singapore as compared to India because of pricing restrictions in terms of there being a cap. You can't get more than the fair value, and therefore agreed returns or become a little skewed for investors. So it's a preference for certain types of investors to come in at the Singapore level, especially if they think that liquidity will be easier there. But otherwise, legally, there's no issue with coming in directly to the Indian company. And again, you'll find a host of examples where both institutions and individual investors, family offices come in directly at the Indian company.
Okay.
But so we've had mirrored structures as well, right? So we've had situations where some people prefer to be in India, some people prefer to be in Singapore. So we kind of mirrored the shareholding economically, so that when there was an exit, it both happened simultaneously. And no one was, other than tax of each local jurisdiction, no one was worse off than the other.
Yeah, but I think it boils down to control as well, right? So if you come in at the parent level, then you have a better control over the entire operations of the parent company, which is why most investors would prefer to come in at the parent level as opposed to the individual Indian subsidiary level.
Fully agree. But say, for example, if it's via the safe instruments or via the family and friends as an angel or a pre-seed, so will it be better to dilute in the respective country subsidiaries from a company point of view? The second is, yes, from the investor point of view, they would like to be part of the holding company, which is a preferred modality. But when it goes to subsidiaries in different countries, will it be more beneficial for the company to dilute on the local level and then, as what Jerome said, it should be equated in the holding company, which will be the best route to go, especially with the safe instruments that we are signing with the local players?
See, on the face of it and intuitively, the subsidiary would be the better option from a company perspective. But obviously it could differ, facts and circumstances could differ from each company, but intuitively and logically, I mean, you would prefer lesser dilution at the holdco would be better for you, right? So.
Correct.
Got it.
But the issue, I mean, I'm just looking at it from why a investor would, well, okay, from a valuation perspective, then you'd be valuing each of your subsidiaries and diluting each of your subsidiaries, right?
For the respective markets, right?
In each respective market. From an investor perspective, if there is intellectual property flow between the parent and the subsidiary level, then, you know, the same benefit that they'd be getting at the holdco level, they should be able to get it for all the markets that you're operating in, right? Especially if you have a brand or there's a brand value that you're trying to develop. I mean, that's an investor's argument, but I'm not going to, I mean, your question was more from a company's perspective and Vishnu's answer.
From the company's perspective, like say, for example, if you are test bedding in Singapore, the Singapore market being the parent company, but if you say we go to Vietnam versus India, the market shares are completely different. So the funding will also be different, even though the IP and the technology being the same, which is getting replicated. So the investor who's coming in from a bigger market like India, Indonesia, they prefer the bigger share of the pie, vis-a-vis getting diluted from the holding company.
No, fair enough.
Yeah. Thanks. Yeah.
Yeah, and again, as I said, you know, you should, you know, when you look at your India operations, you know, see what are the other more tax efficient methods in which you can fund or take money out, and therefore, you know, keep in mind that your brand is important, even though it may be at a nascent stage. You can still put some value to it and see what royalty you want to get for it, and of course, you know, through other technology transfer methods, and try and you know, monetize your investment through that route.
Hey, thanks. Got it.
So moving in again, keeping, yeah, just one. Yeah, moving into, I think, a couple of areas which may be of importance to you all in your businesses, and you know, the kind of slides, so that information that has been shared with us. I think data processing and privacy laws are increasingly becoming you know, significant in India, both in terms of from an investor perspective and a government perspective. So currently what we have are privacy protections based on common law, which are principles you know, generated by the English courts over the years, and legislated in the form of the Information Technology Act. There is, of course, a wholesale you know, amendments in the works for a comprehensive data protection legislation. But currently, you know, these are the two sources of law which deal with data processing and sensitive personal information. In terms of the very basic framework, it would be similar to you know, Singapore, so the standards are probably less stringent. But yes, if you collect personal information, especially you know, sensitive information, which can, you know, allow someone to determine the identity of the person, such as you know, bank accounts, biometrics, passport information, etc. Then there is a user consent which is required to be obtained, and setting out the specific purpose for why you're collecting the information. So your T's and C's on a platform or on an app need to be comprehensive enough, and set out clearly the purposes for which you are you know, taking information, and what you're going to do with that information. So if you're actually going to share that information for your business requirements, you plan to monetize in an anonymized fashion some of that information, you'll need to you know, clearly put that out in your T's and C's on your app, so that the person who's giving her consent is aware of you know, what her information is going to be used for. Note also that consent, like again in most other jurisdictions, can be withdrawn. Right, so there is an opt-out, you know, right that you'll have to give to the person, as difficult as it makes it for your business at sometimes, but you'll need to provide that opt-out information. As far as storage is concerned, most of this information, and we'll accept the third bullet, can be stored offshore or can be stored on cloud, as long as it conforms to certain basic standards set out in our Information Technology Act, which are typically ISO standards. So given that you folks are in Singapore, the standard may already be a little higher than the statutorily prescribed standard. So you should be okay there. A lot of the information that you get from your Indian subsidiaries, as far as personal information is concerned, transaction information is concerned, can be stored offshore in Singapore or on various cloud servers. What can't be stored offshore and what needs to be stored in India, and ambiguity on whether even backups can be kept abroad, is payment/financial related information. So where it's payment related data, whether through transactions on prepaid cards, on app-based wallets, that information needs to be stored in India. So that could potentially add to your costs if you're in that business where you are accessing or want to access payment related data and financial information related data. As a platform, you can structure yourself to ensure that you don't have access to the data if it's of not much use to you. So you can, if you're selling a good or service on your platform, you can make sure that the payment is routed through a payment gateway directly between the vendor and the end customer, so that you don't have access to that information, and the Indian payment gateway is actually processing that information. But if you're in the financial services, something as common as WhatsApp Pay or other cards or applications which allow for financial transactions or allow for money to be transacted using your app or using wallets or cards designed by you or marketed by you, then you'd probably have to factor in cost of storing that data onshore in India. I'll briefly, sorry, were there any questions on the data privacy part?
Jerome, Dana here again. So, regarding this financial information, I have one question. We being a global portal, taking orders or bookings from any part of the world. So say, for example, in this specific case from India, so if anyone is buying our services using the credit card or debit card, which is processed via the payment gateway in Singapore, and we don't store any information because it's a pass-through information. In that scenario, what is the regulations that we need to fulfill? Yeah, it's not only for India, because the booking comes from anywhere from the world, something like an online booking kind of thing.
Yeah, and this is something that online players have been grappling with. So world money transfer, some of your online travel companies, Yatra, etc. They've all had problems with such trades. Now what they have had, and again the regulation keeps evolving, but they've had discussions with the RBI where the RBI has said that at least that portion of the India trade must be accessible to me, must be stored in a particular manner, even if it's not onshore, but I should have access to it if we want to call on that information. So a lot of some of these agencies have had discussions with the Reserve Bank of India to see how what exceptions can be carved out, subject to them being able to convince the RBI that there's a robust enough process offshore storing the information and being able to deliver it to the central bank if ever asked for. So that's a discussion point a lot of people are constantly having with the RBI to see how they can structure their businesses to make sure that they don't fall foul of this regulation. Yes, there is some ambiguity in terms of global players and how they're able to manage this particular aspect of the law.
Hello, I'm Brian from Q Signage. In our case, we are using a smart screen that interacts with villagers in the rural market, which means we do have a camera that's on. So what does the Information Technology Act or Privacy Act would have anything to say about public recordings and all that?
Not specifically, but again, you know, as I said, these are common law principles. Again, we, you know, the advice would be to, you know, make sure that one notification is given to the person that the call is being, you know, or the interaction is being recorded, either audio or, you know, on an audio basis or visually. Two, that consent is taken, and three, you at least give the persons a reasonable idea of what that information is going to be used for. So though the Information Technology Act doesn't specifically deal with it, it is governed by general principles of privacy that any call record, any recording would have to be disclosed to the person, and that person has the right not, therefore not to participate. But you'll have to disclose. For example, I mean, you even in India today, much before we even started talking about revamping the privacy law, if you called up a call center, you know, for an airline ticket, they tell you that the call is being recorded, and you know that you can opt out. So the same principle would work there as well.
But in our case, somebody walking past a camera, they don't have a chance to opt out of it fast enough. So with a phone call,
again,
this is when we, you know, there's no set answers is what I think we're trying to say to you. So if there's a dispute, then, you know, we'll have to see how we present the case, because if there's recordings of this matter and it's being shared, then I think you're in a weaker position. But if you're processing gestures, then to my mind, at least, it seems like you're not really sharing that information with anyone else, and it's basically interactive. Then, you know, there's no, I think you're on a stronger footing there.
Yeah. Okay.
yeah, I kind of agree with what Karun is saying there. Yes, of course. Okay, moving on to IP and you know, how you protect both content and know-how. So we do have you know, copyright protections for original content. If it's an employee, you know, generating the content, or any third-party consultant generating the content in India, then there are certain specific, you know, provisions which you need to put in. You need to put in your contract to be able to ensure that the copyright or the IP is, you know, vested in you. A couple of examples being that, you know, you need to say that it's in perpetuity. If you don't, then it's a 5-year default term, and then the copyright could go back to the original author. Second, you need to say it's on a you know, global basis, or set out the territory. Otherwise, it's just considered to be in India. So few of your, you know, your consultant contracts, if anyone's generating content or generating you know, IP for you in India, you need to make sure that those contracts, even if they're governed by Singapore law or English law, since the content is being created in India, you just need to make sure that those agreements have you know, the required provisions. From a registration perspective, Indian law recognizes most you know, global patent and copyright databases. So we're a member of WIPO, and therefore, if you have protection abroad already registered and you file in India, then you know, the protection that you have abroad will be the effective date that you get protection in India as well for that particular patent or copyright that you need to you know, protect in India as well. As far as trademarks are concerned, this is the most obvious, but a lot of people you know, kind of slips their mind, I think, not to register trademarks in India, but it's important too, because there's a lot of passing off. There's a lot of you know, similarity in names that Indians tend to you know, replicate once something becomes a little famous. So it's a simple thing, but you know, please remember to do it when you come to India, even if your trademark is registered abroad, it's much safer, it's much more sensible to, have those registrations in India as well. Since Karun has spent some time on this, I wouldn't want to bore you guys more on the IP. So any specific questions, I'd be happy to answer. One topic that we thought we'll briefly touch upon, which a lot of people have an apprehension about in India, is about how enforceable are our contracts, how responsive is the judiciary to enforcing contracts. So while we have to admit that, it's probably not as efficient judicial system as, say, Singapore in terms of timing, in terms of sanctity of certain types of commercial contracts, there has been vast improvement over the past 5 to 6 years in terms of judicial enforceability of contracts. So one, we've moved, especially commercial contracts, moved into a system where most contracts are subject to institutional arbitration. To give comfort to foreign players, we have SIAC, which has a center here, and you'll see a lot of domestic contracts also, subject to arbitration under the SIAC rules. So that again gives a degree of sanctity in terms of process and timing. Indian courts now, all high courts in India have a special commercial court division meant to again look only at commercial contracts in excess of a particular value, and therefore give judgments faster. We're seeing a lot more. There was a time in India where the bogies of saying I need a regulatory approval, or this violates exchange control regulation, allowing people to breach contracts. That's changed. There are High Court and Supreme Court judgments which clearly say that requiring regulatory permissions or exchange control or restrictions which are exchange control based cannot be the reason for breaching your contracts, and therefore honoring more such contracts. So I think from a business perspective for y'all, when y'all do enter into contracts with Indian parties, your default should be to try and negotiate a SIAC or institutional arbitration, even if the seat's in India, and try and keep your jurisdiction as far as courts are concerned in some of the larger cities like Delhi and Bombay, where the commercial courts are a lot more responsive and faster in enforcing some of these contracts. As far as taxation is concerned, for the subsidiaries that you all may look at setting up, the tax would range between 22 to 35% with the various cesses on the income. For any imports that you all do, there's a base custom duty which would vary between 18 to 20, in some cases nil, but otherwise the base custom rate would be about 12 to 27% for the kind of services that you all look at. There's an internal goods and services tax as well, which again, depending on the nature of the good, is typically between 12 to 18%. And as I said, the technology transfer agreements, royalty agreements that you may enter into with your Indian subsidiary would typically be taxed at around 10%. And then you can treat that as an expense as well for your Indian tax purposes. So I think that's just a basic supplement to what Karun spoke about in terms of doing business in India. So to throw open the floor for questions again.
You have any questions? So there's a question from Paula from Versa Fleet. Are there any laws with regards to privacy or data protection similar to Singapore's PDPA law? Vishnu, do you want to take that?
Yeah, so I think it will come in very shortly, Paula. There are steps towards similar legislation, but not yet there right now. But it's a matter of I think you know, by mid 2021 we should have it.
Any further questions?
Hi, I'm Dhruv here from TOTT. Wanted to ask you about the free trade agreement which India and Singapore have. So like we will be helping certain brands to import certain products in India. So how does it help or in terms of taxations, especially with the custom duties?
So you just on the free trade arrangements, you're saying?
Yeah.
Right now, see, I mean, as you're aware, right, we unfortunately we haven't you know, opted for too many of them. But Kuwait Singapore, it would still be based on the double taxation avoidance treaty. Yes, of course, if we enter into a larger free trade arrangement grouping, it would be determined by that treaty. Having said that, domestic law still needs to, you know, it still need to be amended to give effect to those, you know, free trade arrangement benefits. So as of now, generally, and with Singapore, it would still be the double taxation treaty which would govern.
Okay.
We unfortunately opted out of some of these larger groupings, right, including RCEP, etc. So, I mean, jury's out on whether it's a good decision or not, but because of that, it then boils down again to double taxation treaties.
Yeah, Dana here. Actually, when it comes to taxation, being a startup, what is that specific for startups? Like, are there any what do you call green holiday periods across the board as a startup, or for specific industries? Any of that information as part of the taxation?
Yeah, for the Indian company, there are certain tax benefits if it's generally in the technology related sector. There's known as an angel tax exemption for about 5 years on corporate income taxes and certain you know, share premiums, etc. that you get. So there are exemptions. One, you have to get registered with two authorities. One is the Ministry of Commerce, and so that gives you a set of benefits which are not necessarily tax related, but you know, single window clearances, exemptions from certain employment statutes, etc. And then once you get that registration, you'll have to apply to the income tax department for exemption as a startup, which typically you know, would be for a 5 to 7 year period. Okay, it's quite broad in its ambit in saying that, you know, anything related to technologies.
Okay. And does it from the date of registration all those things kick in, or from the date of incorporation all those things have to be accounted for?
I think you have to apply within 12 months of your incorporation, and then it you know, you'll get the benefit from the date of your incorporation.
Okay, noted. Thanks.
Okay. If we have no further questions, Siddhi, are you there? Do you want to wrap this session up?
Sure. No, this is really informative. So some folks were asking us, are you comfortable sharing the slide with them in future? Karun and Vishnu, if yes, then please share it with us, and then we'll do the same.
Sure. We're just looking for space to put Vishnu's contact details. And once we do that, we'll share it with everyone.
Great. Thank you so much. Before we log off, and I would like to thank Vishnu and Karun once again. This was very informative. We saw a fleet of questions coming in. So thank you, startups, for this interactive session. Thank you, Vishnu and Karun, for giving an in-depth overview of how the legal and taxation works, specifically in these 3 sectors in India. Before we close, can I request everyone to switch on their videos so that we can have a snap and share it with the other folks who are missing this session.
Unfortunately, I must, as I told you the other day, my camera is still not working, so I will have to sit out the photograph.
Vishnu will superimpose your snap, don't worry.
Sure.
Just waiting for all to come in.
Karun, well done, man. This is Chandru here.
Oh, thanks, Chandra.
Okay, I'm not forcing the others who don't want to switch on their videos and they're shy, but hey, Sabrina, last call, guys, please switch on your videos so that we can quickly have a snap before we take a break for 30 minutes and for good 50 minutes and come back at 4. Great. So everyone's here. Please say cheese. I still use the old words. All right, there we go. Awesome. Thank you so much. And thank you, Karun and Vishnu, once again.
Thanks very much, TiE and SG Singapore. Appreciate it and appreciate the opportunity.
Thank
you for sharing. Thanks.